and welcome everyone to the IVI IPO, Independent Voters of Illinois, Independent Precinct Organization, Cash Bail Town Hall. I am Jim Garfield. I'm going to be serving as your moderator for tonight. We're hoping to have this done by about 7, but if people want to keep talking afterwards, we can go for a little bit longer, but we don't want to hold people too late. So, some quick introductions of our panelists. First, we have Ali Abid, and please correct me if I'm saying that wrong.
No, that's fine. Ali Abid, it's all fine. I'm a program coordinator at the Cook County Justice Advisory Council, which, as along with Rebecca, that department is the criminal justice and juvenile justice policy and grant making arm of the Cook County Board President Tony Preckwinkle. I'm very happy to be here, and along with Rebecca and others in the county, we've helped sort of administer the changes to the bond reforms that have already happened at Cook County over the last several years. That's me.
Fantastic. Our second panelist is Rebecca Janowitz, who is currently the Special Assistant for Legal Affairs at the Cook County Justice Advisory Justice Advisory Council. She previously served as a Director of Reentry Services for the Cook County Sheriff, and she holds a law degree from Loyola University of Chicago and a Master's in Public Policy from the University of Chicago. And our third panelist tonight is State Senator Robert Peters, who's had a long and deep passion for public service, cultivated by numerous events throughout his life that had a profound impact on him and the people he cares about. Currently, in January 2021, he was sworn in for his first full term as state senator, during which he plans to continue fighting to win real safety and justice for the communities he represents. And in the 102nd General Assembly, Senator Peters will serve as the chair of the Public Safety Committee. He will also serve as a member of the Criminal Law, Environment and Conservation, Health, Human Rights, Labor, and Revenue Committees. So thank you all three for being here tonight, and thank you everyone else for attending. So I want to get right into it so we can go ahead and get through as many questions as possible. Whichever one of the three of you wants to go ahead and take this, we'll start very generally. What is cash bail?
Well, I mean, I think I won't speak nearly as legally defined as Rebecca or Ali might, but I mean, I would define cash bail as a form of wealth-based detention that says that in a neutral way is supposed to be you put up a collateral, so wealth or money, to determine whether you are going to return or not to jail. Whether that's actually how it works, that's sort of how I would define it as. It's a wealth-based collateral for your one part your freedom and another part your ability to come back or to determine you coming back to court, to come to court. So that's sort of how I would put it, but I feel like there will be a much more legally defined way of defining bail from the other two.
So Rebecca, do you have a more legal side of things for defining cash bail?
Well, what the law says in Illinois about bail, and we made big changes recently because we decided to follow the Illinois law. Remember, Illinois law says that you can be required to post a bail bond, which you pay a percentage of that. You come up with a percentage of the amount that you would owe if you don't show up for court. You pay that amount and you can be released. And Illinois law says that no one should be asked to pay an amount that they can't afford to pay. And in the past, this has caused a great deal of unhappiness because basically what judges did was to say, instead of just saying, I'm not going to release you because I think you're a danger to the community, coming straight out and say what they think, they would just charge a bond that they knew the person couldn't pay. And that was wrong. And on the other hand, sometimes cash bail is helpful to people, particularly working people, because if it's set at a reasonable amount, a low amount, a person gets a bond of $1,000, they pay $100. This is the famous old $100 to walk. And a judge can impose that when someone appears in front of them who's a working person and they believe is basically going to show up and is basically going to cooperate. But they look at their record and that they see that a couple of years ago they were involved in something and they missed a court date. So this is the judge saying to the person, I know you're working, I know you're going to come back to court, but just to make sure, it's going to be $100 to walk. If you look back on the past 8 years or so, you see that by following the law, we drastically reduced the jail population. And I think that's something that should be gotten out towards the beginning of this program, which is when we stopped putting bail that was so high no one could pay it, a lot of more people were released. Now, the bail that some people can pay is what we call an I bond, which is where you don't pay any money. And that is the one that works for a great many people, not being asked to pay anything. So when you start seeing people being asked to pay nothing and be released, but at the same time, we started reminding people of their court dates. I used to find this incredible. My dentist won't leave me alone. They know I don't want to come. So they send me endless text messages. And what we've started to do in Cook County is send people the same annoying messages that you get from the dentist, reminding you to come. And that improves attendance. So I think that you've got to understand there are a lot of different ways to get people to court. And we saw an enormous decrease in the jail population, which thank God happened before COVID hit. But actually following the law and giving a lot of people I bonds because that's all they needed, and giving other people bonds they could actually pay, drastically reduced the pretrial population in the jail. It also meant that a lot of people were told, there's no amount of money. I'm holding you without the possibility of bail. Look at what you're charged with. Look at the 6 times you've been to court on felonies in the last couple of years. So they would just say no bond, which to me is the truth, instead of setting some huge bond that they knew, that the judge knew when the judge was imposing it, that the person would not be able to pay. Okay. So I think we've made progress.
Okay.
Long answer. Sorry you asked me.
That's okay. There's a lot to unpack here. It's a big issue. So I want to ask Ali, so why is it that that cash bail was seen as problematic? If you could set different amounts for the different people, if it encouraged people to come back as working folks, as Rebecca said, why was it problematic?
Sure, I'm happy to answer that. I just something I wanted to clarify since I joined a little bit late. Senator, you said you were leaving in a few minutes? Is that true?
I'm going to stick this out until about 6:20. I'll push it out. The reason being, so everybody knows, there's just a lot of county chairs downstate. And we have a town hall. It's me, a police officer, and Senator Sim. So I think it's also important that we have the downstate people need to be reassured about what we just did.
Yeah. So since we've got 8 minutes with the senator, I was wondering, could perhaps the portion of the thing where we asked the senator what the bill does, and then I'd be happy to do some table setting about the numbers, about where we've been with cash bail and sort of like the instances, and I can fill in that background. Would that be all right?
That's fine.
Yeah.
So
okay.
I'll go ahead and start with the senator, then come back to you in a minute.
Yes, absolutely.
Okay. So there's been a bill passed very recently that has a whole bunch of different criminal justice reform elements to it. One of them was the elimination of cash bail, and Senator, you were one of the central figures in getting that through. That's right?
Oh yeah, that's right.
Okay. I'll ask it this way: what had to be left out of the bill, and why?
Well, I did not expect me to be answering this question this way. So there were a few things that I think we really wanted to get done that we weren't able to get done in this package. And we had, just so everybody knows, we had 9 hearings, 30 hours of subject matter hearings. Some of these bills have existed for quite a long period of time. So, we keep hearing about how this sort of came out of nowhere and, oh my God, everyone's shocked, but actually not. The people who oppose it have actually given statements on many components of this bill throughout the years, through many sessions. And some things that we really wanted to get done, but we weren't able to get done, is qualified immunity, which sort of protects cops and bad officers and would essentially remove their immunity, which is really sort of a system of you have to have, the best way to put this in layman's terms is qualified immunity means that if let's say a police officer did something that was wrong, they would have to have done the wrong thing the exact same way multiple times. So, and the problem is that's never going to be the case. It's never the exact same bad behavior every time, and therefore they get immunity. And the idea is to remove that, which opens them up to greater liability within the criminal legal system. Or within the legal system. So that's just qualified immunity and me trying to put it in layman's terms. And the other one was the CBA, the collective bargaining agreement language, which one of the issues that we had was trying to balance out the terminology of peace officer and police officer and how many people would be impacted by opening up the collective police officer collective bargaining agreement. So we weren't able to get that and qualified immunity done. And then the last one, which has been a project and worked on for quite some time, particularly with the ACLU, is reforming truth in sentencing laws, which are a product of the late 90s, which is sort of comes from the Willie Horton-esque, if people remember Willie Horton, this idea that you're letting out these people that they need to serve their time, the full time, no matter what the situation is that they've been into in terms of, being in prison, whatever programming they may have or not, that they have to serve their full time. And so the idea was to reform these truth in sentencing laws to say, okay, well, they actually get credits for being part of programming and rehabilitation to come out into the world. And we would give folks more credits to reduce their sentence so that they can come out in the world. And we weren't able to get truth in sentencing reform done. So those are three major things we weren't able to get done that I think, particularly with qualified immunity, we're going to have a task force or commission to look into it. Collective bargaining, I think it's just a broader conversation that we have to have, a longer term one. And then truth in sentencing is going to be a constant project. I think that one day when we have another chance to do a package, we'll be able to get truth in sentencing laws done and truth in sentencing reform done, hopefully sometime in the future.
I thank you for that. Two of the things you mentioned there that didn't get done in this particular bill, collective bargaining and qualified immunity, both seem to directly go towards police officers, peace officers, call them what you will. Was that because there was some kind of a pushback from police organizations, or was that simply it didn't coalesce in this bill in legal terms?
Well, look at you! You're putting me on the spot here. So it's a combination. I appreciate it. I think it's just a combination of things to break down. So one part is, yes, there was a lot of pushback coming from law enforcement. So that existed. You have your more moderate conservative members who that pushback was heavy on them. But the other part is, it's not like other pieces of the bill didn't have pushback. The difference is there was a broad coalition around many pieces of the bill. So you could sort of, in the tug and pull of legislative making in the sausage making, you didn't have that broad coalition around qualified immunity or collective bargaining. It exists in a theoretical sense, like, you might see in a libertarian paper someone write about it, and you'll also see that in the progressive paper, right? That people will write about it theoretically, but not as organized. Where with ending cash bond, there was a long-term organizing project on that. The felony murder reform that we did, for example, with the Lake County 5 situation, if nobody knows what that is, that's the best way to describe it is like guilt by association within felony murder. That again, organizations have been working on that to the point where a prosecutor, the state's attorney in Lake County, lost his election to a reform state's attorney candidate. And part of that built up to that was because of a situation in Lake County around felony murder. So, And then decertification had a lot of effort, a lot of push coming from the Attorney General's office, who was organizing stakeholders on that for months. So I think it's one part that you're going to always have opposition around these things. I mean, look at how people are responding to the bill. But it's the question also is, do you have something that organizes a counter to that, or something proactive on that? And I think that other components had a more organized force to be able to speak to my colleagues in the Senate and the House.
Right. How much longer do we have you for? Do you have to get going?
I mean, I can answer one more. I mean, as long as the county chairs downstate are, I think there's a long introduction period coming from Representative Buckner, and I'm sure he'll stall a little bit. I'll answer one or two more. I can talk forever. I was born deaf and had a speech impediment, and I grew up with an Irish Catholic father, so I have this weird gift of gab, to the point where my dad, who was not actually a talker, got stuck with me talking to him all the time. So we'll have the mistake of me being on here talking forever about 100 different stories about policies and life. So yeah, if you want one more question there, I'll answer it 4 different ways for everybody.
I'll tell you what, I'll have one more for you, because as you mentioned, you're going down to, well, not going down, you're going to a different meeting with the county chairs, you said mostly downstate, to kind of explain how this bill works and how it's going to be implemented. Why is that happening after the bill's passed, rather than as part of the convincing process to get them on board with it?
Well, no, I mean, the way to put this is, we did a lot of meetings to talk to a lot of people around this bill. So I'll repeat, we had 9 hearings, 30 hours. Organizers around the bill held town halls across the state: Lake County, DuPage County, Champaign County, McLean County, the Metro East area. I mean, they were Sangamon County, where Springfield is. They actually a lot of hearings. What we're seeing here is, the reason we need to do this is, even if people heard about it, a lot of the opponents are throwing out a bunch of misinformation about what is in the bill and what it does, to the point where I think they need to rehear about what we actually did. And the other part about this is, what has become clear is, for instance, we don't have private bail in Illinois. We have what's actually historic about Illinois in the history of money bond is that multiple decades ago, 4 or 5 decades ago, we got rid of private bail, and we had a public bail system. That is that's where the 10% piece comes in that Rebecca talks about. And so, but the thing is, everybody else around us has private bail. And so the private bail industry sees what we've done in Illinois, and they have flooded the state to try to defeat bond in its implementation, because of its impact in states like Arkansas or Texas, or even nearby, like Indiana. And so what we know is that there's a huge political effort to put pressure on people in what you would describe as a swing area, even with misinformation. So part of this is to make sure that people understand what truly is in the bill, to reassure them that they're going to have their back covered as they speak on this, and to understand what they need to say to the public, to say to people, and let them know what's actually in this piece of legislation, so that they don't allow, Jim Durkin is out here, he's the minority leader, and he's saying all this wild stuff. So a part of the bill that I want to get into is, he says, this is horrible for domestic violence. This is a landmark piece of legislation that has support from 3 major domestic violence advocate organizations and sexual assault survivor advocate organizations. And the Illinois Coalition Against Domestic Violence has stated that this is a piece of criminal justice reform that puts survivor safety first, right? It is, as opponents are screaming about a thing, they're not actually listening to the advocates on it. The other part about this is, they're out here talking about how this is just going to let criminals run wild. And yet, for example, Kyle Rittenhouse was out on bond. I mean, he had a bond. It was, $2 million. He paid $200,000. He had his right-wing donors flood in a bunch of money to pay for his bond. He put the wrong address in his court documents, so he technically had gone missing. And it just shows that we have a tiered system of when it comes to who gets to have safety and freedom and liberty and justice and all that. And the best way to put this is the status quo is that people like Kyle Rittenhouse have the privilege to be able to pay out when we turn the system into trying to focus simply on, are you a threat to a person or community, and to focus on safety, not money, as a reason for one's ability to have freedom, liberty, justice, and all of that that we need and deserve.
Thank you, Senator. We'll let you get to that meeting then, so you can go ahead and help explain all that to the folks downstate. And then we may follow up with some questions by email later if someone has something specifically directly for you. So,
and I'll just say, the two other folks on this panel are going to be, I mean, like I said before we got on, you know, when they would talk to me, I took notes all the time because they're like experts on this issue. And I apologize that I have to leave. And the thing about this bill is I didn't expect me to be so out there. But I know you have two amazing other panelists who can talk about this bill from a data point to the broader point of what we're hearing in terms of messaging and really dig deep. So I just want to say thank you all for having me, and I really appreciate it.
thank you.
Thank you.
Thank you.
So I'm going to go ahead and turn back now to Ali. I asked you before.
Sure.
I think the question was like, why is it seen as problematic if it is in fact encouraging folks to come back for their court hearings?
Right. So the question of cash bail overall. So I'll give a sort of like a little bit of a timeline of how cash bail has been used just in sort of recent Cook County history, which is what I'm most familiar with, and a little bit of the comparative research that we know about. As of 2010, 11 to 13, the Cook County Jail was typically over 10,000 individuals. It was the largest single site jail in the country by population. A majority of the individuals who were there had been given a monetary bond as their bond decision. So when you go before a judge, you have a variety of options that a judge can make a decision on. They could hold you on no bail. That means they're just being sent to the jail because they've deemed you too much of a flight risk or risk to public safety to let you out. They could determine that you're not too big of a flight risk or risk to public safety, and they might give you an I bond, which means you can just go. We trust you to come back based on your background. And then the middle options are some sort of electronic monitoring, which is really another form of detention, and sort of home confinement is the term of art that have been used in Cook County for ages. There's other conditions that they have to comply with, checking in with this person or that person, other pretrial conditions, or monetary bond. And monetary bond was the go-to for Cook County, as is for large parts of the country. The issue in Cook County was that we were both issuing monetary bonds at a higher frequency and a higher individual amount than most any other large urban jurisdiction throughout the country. Our jail was filled with individuals. The great majority, 67% of the individuals at Cook County Jail in that era were there because they had a monetary bond that they couldn't pay. And that was indeed not in accordance with the law as it is written. In the law as it is written, in the case law in Illinois, says that monetary bond is a form of release. You have the whole point of giving someone a monetary bond is you do not want to hold them in jail. So if you're using it euphemistically as a form of release, but it's too high of an amount to release someone actually that they could never pay, that's improper. So we were over relying on monetary bond, even by the standards of the law as it was written, so that was our issue. We instituted a number of reforms starting in 2014 and 2015 and really kicking into place in 2017, where pretrial risk assessments would be used and monetary bond would be used less. So if a person is too dangerous to be let out, they should not be let out, and the judge should order no bail. And indeed, the amount of no bail orders went up tenfold. But if a person is not that much of a risk, they shouldn't be let out. So they should be let out on an I bond preferably. And if you need a middle road, you can have some other pretrial conditions. And we see a great increase in those. The problem with monetary bond that we'd always had in those previous times, and they're just inherent to the system to an extent, is if a person is very dangerous, if everyone gets a monetary bond, a person who is very dangerous but has money can get out if they're part of organized criminal outfits, gangs and stuff like that, and they can access the money, or just individually wealthy, they can get out. And if a person is poor and they're in for retail theft and they get a monetary bond, which was a common occurrence before our reforms, they would sit in the jail for however long their case would last. So our reforms are sort of like a way of showing a lot of things what happens when you reduce your reliance on monetary bond. No bail orders went up. As a person who's just commented in the chat, a person like Kyle Rittenhouse would likely not be let out now because our no bail orders for more serious offenders went up tenfold. We are more likely to hold dangerous offenders in the jail now and more likely to let people who are just there on retail theft and other crimes of poverty out than we were before. And so now the amount of people who are in the jail because they have a monetary bond they can't pay is approximately 10%. This is the last quarter of 2019 numbers that I'm referencing with that, because 2020 was exceptional because of COVID and such. So
I believe you said before it was 67%. Was that also a 2019?
No. That was well before the reforms in 2011. In 2019, 2 years into our reforms, it's 10% who are there because they have a monetary bond they cannot pay. And that could be for a variety of reasons, but the goal has been, we make sure if we're going to do a monetary bond, it should be an amount that a person could actually pay, with the theoretical understanding that paying monetary bond would help a person come back, encourage them to come back, because they would get a refund of a big portion of that. Now, what this law does, and should I get into that now, or do you want me to pause about just there's some of the issues with monetary bond?
Well, we'll get into some more details of that. I want to just check real quick. Either one of you can answer this. What types of cases require a bail hearing? And as a quick follow-up to that, what discretion do judges have on cases that bail can be opposed? And is that changed by this most recent bill?
So every single type of criminal case requires a hearing. Every felony requires a standard bond case, bond decision. A misdemeanors do as well if a person is being held. In certain instances, a person can obtain, for misdemeanors, releases from the station house. They don't need to, in a couple of different formats, they don't need that, but every felony needs a standard bond decision. Rebecca, do you have any sort of clarifying thing on that? No.
That is correct.
Yeah, well, so there's that. In terms of what discretion a judge has, so there are certain types of offenses that cannot be offered a bond. That's in statute. They're just too serious, we're not going to offer them a bond. Everything else has that range of decisions that we're talking about. And a state's attorney can always object, and a public defender or a defense attorney can always offer mitigation circumstances of which way a judge's decision can go. The pretrial assessment and risk tools we do, screeners that inform the judge via different scores, what the person's flight risk is and what a person's risk of public safety is, or new criminal activity or violence. All those things can be taken into account, but a judge can make a decision across all those lines, whether they think electronic monitoring is appropriate, or a monetary bond, or other sorts of pretrial conditions of release, or no bail, or I bond, which is release upon their own personal recognizance, no other things, or combinations thereof. What this bill does is that in 2023, it would remove the money bond as an option. So you have no bails, and you have electronic monitoring, and you have other forms of pretrial conditions, and you have I bond availability, but money bond itself wouldn't be an option. So it sort of neatly removes that option from the statute. That's what it does. And
I
so
wanna-
in Cook County, for the net effect on Cook County, that's 10% of the jail right now that we would have to come up with a different bond decision for, one way or another.
Now, someone mentioned in the chat as a question, they have a client downstate who posted $75,000 on a murder charge, and they were released on that bond. Will the likely result on things like a murder charge in the future when there is no monetary bond, will it almost certainly be simply no bond?
So that's a question about how the judges are going to respond to not having the monetary bond option, and that's largely has to do with the cultural response of judges in that sort of like sector, and it's hard to tell what that's going to be. I see another question about how do you deal with the constitutional requirement that a person is entitled to reasonable bail no matter what it is. So the whole thing about no bail, if just in the same way that a person shouldn't get a too high monetary bond amount, they shouldn't be given no bail. And there are vast swaths of offenses that should never be given no bail, and that's also enshrined in statute. So there's statutory things to point to and argumentative things to point to that would prevent no bail from being overexpanded. However, to guess at what judges will do, we do not know yet. Right now, we can just guess by sort of like our reduction, for what happened to us. We saw that the most high bonds did get turned into no bails for certain types of offenses, but a great majority of things, monetary bonds turned into I bonds for less serious offenses. So there was an overall reduction in pretrial detention in Cook County, and then this would be a 10% further to go down that track. And it's the trickiest 10% because obviously they're deciding on monetary bond for a reason. But that's what it looks like from the Cook County prognosis.
Now Rebecca, I want to talk for a second. One of the things that you mentioned before we actually got started tonight, and that people have been asking questions about, is about this electronic monitoring, and what the penalties are for violating electronic monitoring rules, and how long does it take if someone does break those rules? How long does it take for action to be taken?
In my experience, action is taken rather quickly. If someone, and sometimes when the person hasn't actually violated anything. So you've got to understand that, and this is my great fear. I'm not worried about, I think we may be making a step forward actually in some ways if there's no such thing as cash bond in a murder charge. There were cases in the past, one I particularly remember was very distressing, where someone was charged with murdering a young man and paid an enormous bond and left the country on the additional passports that the judge wasn't smart enough to ask for. So getting rid of monetary bond for murder charges might be a good thing, because we should hold those people. We should hold someone if we really think that they've murdered someone. The problem that I see with electronic monitoring comes from two places. The first is that when a judge is setting conditions and they have someone that they're somewhat concerned about, and I'm not talking about someone that they think might murder someone again. I'm not talking about a murder charge. I'm talking about someone who keeps committing retail thefts or does other things that are bad and are wrong and we don't want to see happen, maybe has missed a court appearance in the past. It's going to be, the option that's going to be available is putting that person on electronic monitoring. And I'm concerned that too many people will go on electronic monitoring, that they'll be on electronic monitoring for too long, And I am also concerned that there is a lot of rhetoric right now that says that putting people on EM really creates a very safe situation for everyone else. And this misses a number of key points about electronic monitoring. When you're having electronic monitoring, you're really bringing the jail into the community. You're seriously restricting people's behavior, ability to go about their ordinary lives. You are restricting people's access to pro-social activity. You're restricting people's access to the very things that are the most likely to pull them into having a healthier life. You're making it hard for them to work. You're making it hard for them to go to school. You're making it hard for them to participate in therapeutic programs. One of the things that I say about electronic monitoring that actually surprises people is that we hear a lot about EM at our office at the county, Ali and I. And one of the groups of people that complain to us the most and the most bitterly about electronic monitoring are employers. People who have employees who get put on electronic monitoring. And these tend not to be people working for the kinds of jobs that we all aspire to, but sort of lower level jobs. And the employers lose flexibility, their ability to change people's shifts, to deploy people in different ways. And they're very frustrated by this. But we know that having a job is one of the most important things for helping people build a decent life. So we really have to be concerned about the numbers of people that we're putting on electronic monitoring and also about the length of time that they stay on monitoring. Do they get off monitoring if they are compliant? The answer is usually not. That's not how it works in Cook County. We don't even regularly review the orders. So it's very worrying to see people who are not charged with murder, who are charged with much lesser offenses, having their lives interfered with to the extent that EM interferes with their life, particularly in view of the fact that the technology has changed so much and that it's so much more intrusive than it used to be.
I guess I'll ask a follow-up on that. If it's released on your own recognizance with an I-bond or monetary or electronic monitoring, we're getting rid of that middle category. And we still want to keep track of people, but the EM, the electronic monitoring, has those issues you presented. Is there an alternative other than just no bond or recognizance that would work? Or do you promote one of the two of those?
Well, I think that certainly I think we could have much more supervision of people that's not electronic. We could have people checking in more often. We could have we could have actual people checking up to see if people are working, if what they say they're doing, they could be doing. There's a great range of things that we could do, and we could look at people's behavior and see what kind of things they're managing to do. We could check and see if people are keeping their employment, if they're looking after their families, all those sorts of things. We could check and make sure that that is happening, and frankly, at some level, reward involvement in pro-social activities instead of making it more difficult. I think there's a lot of different ways that could be done, and I think it would help us all be moving towards a healthier community, to having a healthier and stronger community.
Is that? I just wanted to ask real quick, the idea of having actual people checking up on folks, is that realistic and feasible during a pandemic? Certainly.
Well,
I know it's an odd time, but you deal with reality.
But remember, there are a lot of people who are checking up on people right now. Employers tend to know where their employees are. So if someone is working, they know that. Schools, when you're talking about younger people, schools are certainly still taking attendance. It may be your attendance on the video. And if you're a really smart kid, I assume you're doing something that you shouldn't be doing, but it might lead to you making a lot of money someday. There's all those kinds of things. There's plenty of people. What I find is so interesting is we have so many people in our society who are checking up on people all the time. Doctors and nurses are noting whether people are showing up to their appointments. Maybe we should think of ways to make use of that positive information about people and support those positive activities to encourage people to also show up for court. Other things that we could do to help people show up for court should be considered. One is to make sure that they have the bus passes to get there. The buses and the Ls are still running. Make sure that they have access. If their hearing's going to be by Zoom anyway, one of the things we've been spending money on is getting computers and cameras out in the community so people can attend their hearings. These are all things that we can be supporting that are helpful things. And I imagine that for the $12 million we just spent to upgrade the monitoring that we're doing, we could have employed a lot of people to check up on a lot of people. And we could have spent a lot of money underwriting people's transportation costs if that's what they needed, whatever it is kind of support that they needed. Hell, we could be getting people cell phones with some of the money, which is a great way to check up on people and also to allow people to access opportunities. We could be spending some of the money we're spending on electronic monitoring, making sure everybody has a phone.
Yeah.
It's a very key element to delivering services.
Yeah. So I'll add just a couple other pieces to this. One, to some of the things happening in the chat, can EM be customized? Yes, it is often customized to allow people to go to work or receive social services. However, the administration of that is highly erratic, even when everyone's trying to do as best a job as possible, because fact of the matter is our electronic monitoring system and the permissions, the lag of information back and forth from a court to a judge to allow movement is very slow. And when you talk about certain types of emergency things people have to do for childcare or so like that, and certainly with how much the gig economy, which employs a lot of people, Postmates, deliveries, these kinds of things, and the wide variety of movements people would be needed to fulfill those, it's really not well set up for those. So even, the number, even if everyone's trying to work that out, like electronic monitoring does a huge hamper to that kind of work. So there's that. But one thing I wanted to address about this question about what is the search for the middle option? I think, we have to remind ourselves that a lot of the thing we're asking here is not about the reality of what will happen with a person when they're released from the jail, and more about what is a judge comfortable doing. Because the fact of the matter is monetary bond and its effect and actually changing behavior on whether a person returns to court has not been demonstrably proven anywhere. And you can see cases in Colorado and studies that were actually done where there was a little bit of way to do a side-by-side study comparison. Monetary bond had a negligible effect on whether, compared to I-bond, whether a person would show up. And things like Rebecca mentioned at the top of the call, like text reminders about what the date is, had huge effects. Huge measurable effects. So the idea that we have that a person, because they put $400 down, will show up for a court date because the threat of the law coming after them isn't enough, but the $400 that they could get back on top of that is enough, is actually not that big of a population. Usually, the $400 is not the thing that makes or breaks the $2,000. It's the threat of the law coming after you. And if you're not worried about the threat of the law coming after you, then the few $100s that you might miss is not the thing that's going to get you back into court. Most likely what you're missing court for is because the people who are involved in the criminal justice system have of a lot of have a lot of things in their lives that make them incapable one way or another of getting to that court on time, knowing when that thing was, or or caring. And the monetary bond hardly makes a difference. So this idea that we're coming up with a middle option, we have to remind ourselves we're trying to think of something that judges are comfortable doing rather than something that will actually change the situation. Because functionally, the difference between an I bond and a monetary bond that a person can actually pay is there's no difference to the community. Yeah, so that's what I would say to that. Then I'll quickly answer another thing I saw in the chat. Can a juvenile accused armed carjacker be put on EM? Yes, that happens. Yes, that happens all the time.
Now I want to shift just real quickly since we're low on time, although as I said, we can run a little bit over. We've been talking an awful lot about Cook County and about the northeast portion of the state. Is there any information that you guys have about how this will affect more of the downstate counties or the far west counties?
Well, the only information that I have on that point is that I would say that some of the downstate counties, I was saying this before we went on the air, some of the downstate counties actually handle EM better than we do. They make the judges look regularly at cases. You can't just enter an order putting someone on EM for an indeterminate period of time, which, remember, in Cook County could be 5 or 6 years before the case gets heard. So they regularly review whether a person needs to be on EM. I think this is probably because they don't have very much money, and unnecessary EM is something that they are going to be trying to save money on. If in Cook County, you can be on EM for 4 or 5 years. Now, in the course of that time, if you haven't caused any trouble, at what point could we look at taking you off EM? There's a lot of emphasis on punishment. Some rewards are sometimes helpful, in terms of encouraging the pro-social behaviors we'd like to see people engage in, and that will ultimately reduce the amount of court involvement that they have.
So one of the questions we actually got from the group here was kind of related to this. How would it work when person's out on an I bond that they're on recognizance? How would it work when they repeatedly violate non-dangerous to the public offenses?
I'm not sure I understand the question. If they repeatedly offend, they'll be repeatedly arrested.
So if they're out on I bond, it's just recognizance. They go out and they do a series of offenses that are non-dangerous to the public. How would that work? Would there be a new possibility of bond hearing? Would they need to stay on I bond? Would they simply need to be either I bond or nothing?
I think, Ali, what do you think? I think that the I bond would be revoked, at least that they wouldn't be put on an I bond for the next offense.
These so there's a variety of things, and it'll be interesting to see how some of this shakes out with the change in the law, but certainly a lot of violations of conditions of release often result automatically in no bails. Now, that's the case in a couple different types of forms of release. With an I bond, you would probably go up to a different medium level of thing on a subsequent thing, especially if it was a non-violent offense. A lot of this is courtroom specific. So it would be hard to say, and I apologize not knowing sort of a very direct answer to that one. Yeah.
That's okay. So you said it's kind of courtroom specific. Is there anything in this bill or in the reform movement that is designed to try to push more of the discretion away from the judge and into a uniform system, or is it a push to keep it more to let the judge work on an individual basis?
So with this bill, as with a lot of bills that have happened that touch upon the bond system. They have, especially the previous ones that have put in place how to use assessments, things like that. They've added tools to help inform the judge, but they have not taken away judicial discretion. This does remove something in the sense that it removes the monetary bond option, but like we're working in the agencies that'll help administer this, so not as much talking from the perspective of an agency or like an outside org that help push this. But I believe what they would say, and what the coalition of advocacy groups would say, is like their goal with this was particular. Monetary bond is a form of wealth-based discrimination, very ensconced in the law, about whether a person should be held in pretrial detention or not. That is not supported, that does not aid public safety in any measurable effect, when you A/B tested not. So that is the thing they want to remove. Now, judgments not based on wealth, made on something that is more directly tied to flight risk or public safety, is what it should be built around. So that's what it does. It removes one tool from a judicial thing, but it does not limit judicial discretion in any way outside of that. But aside from removing this option of release. So,
And
go ahead.
And in terms of public safety, remember, we're only talking about cases where arrests are made. And we have a very low rate of arrests being made right now in Cook County. The statistic that sort of knocked me over was when David Olson, who is from Loyola, who studies what's actually happening in the criminal justice system. He said to me once, Rebecca, if the police clearance rate for murder cases even rose to the national average, we'd have another 20,000 people in prison. And so then you step back and you just go, oh my God. And presumably some of those 20,000 people who have never been arrested, never even been charged, let alone discussing their conditions of release, some of them have murdered another person. So I think it's very important to focus on, to keep this in perspective. What we really need to see is more trusted and more efficient law enforcement, and building up public trust by actually restoring public safety. And that's just a huge issue. And I do think that, I'll give it to you in a second, Ali. I do think that people's fears are very much reflected in this debate. And we have reason to be afraid. We have crime that we need to do a better job of building safer neighborhoods. And so people say, well, EM is something we can do. That's something here. The technology exists. And I think that we're not looking, there's a danger that we won't look carefully enough at the consequences for an expansion of the use of EM, particularly with people who don't need it. That's what I'd say about that. Ali?
Yeah. And I will say another thing, the bond court judges get a lot of heat for what's happening in crime overall, because that's been one of law enforcement's sort of like flashpoints. So here's a place where we can, every summer we'll turn and we'll point the finger at bond court judges in this bond reform, and like, this is what's happening. And the numbers, as Rebecca said, don't bear it out. The amount of people who are arrested is a tiny fraction of the crime that's occurring, it seems. And then the small subsection of those that might get some sort of bond release being blamed for the large upticks we saw this last year. And really, it was just this last year, we've had 4 years of reducing gun violence in Cook County, alongside all the reforms being put in place. But yeah, so there's all this, there's all this heat being put on the bond reforms and the bond court judges ourselves. I will say this, we have been able to, up until the pandemic and like all these kinds of things, but even during the pandemic, we've been able to move state's attorney, public defender, judges, the whole system into a place where we vastly reduce the jail, and our numbers on public safety, as the Loyola study has shown, have not badly impacted public safety at all. There's been no negative effect of public safety based on the bond courts. So the judges have done a very good job to adjusting to that. I think what's happened, and there's a lot of questions about the pandemic. Yes, the EM population has gone up a lot during the pandemic. And a lot of that is, one, we needed very quickly an option to reduce the jail population. And two, case processing froze to a halt because of the inability to have trials and cases happening.
I would jump in here real quickly and kind of
Yeah.
ask really kind of a last question as we head into our close. And that what you mentioned was the need to get people out of the jail, especially for COVID. The fact that, as people are mentioning, that there hasn't been a trial since March. There's this giant backlog. And so the use of EM has increased significantly. That at this point, it's kind of like a triage of cases, forgetting the ones we have to get through first, and everything else will just have to wait. Now, there was a policy previously that criminal defendants get jail time credit for being on EM. Do you know if that is still in effect? And if so, is that kind of an effective solution of, hey, be on EM or a more efficient EM and then get out? And I guess, Ali, we'll start with you.
Sure. It is still in effect in terms of, the credits for EM and such like that. So all of that's that. The triaging of cases, I mean, it's underway. There are lots of discussions happening between the stakeholders right now about how to process things out. I think one of the major, most promising items of discussion that should likely just be a point of usual practice, the one that Rebecca mentioned that is already used in many other parts of the state and definitely other parts of the country, is if a person's on EM for a while, bring them up for a status hearing and see if they need to remain on EM. And, yes, that will take away their credit, but if they're doing well, they might as well be out on I-bond and not have those encumbrances on them. Like a lot of this is, there's push and pull different factors here between prosecution and defense and the judges here. But in terms of like overall systems management, it just makes sense to do it that way, to give people an option to get off of EM if they're doing well on it. Yeah.
And remember, some people will agree to EM in order to be able to go on working. That's their attorneys also like them to go on working and continue to pay their attorneys. So that's particularly a point with the private bar. But if we can keep people working without having to put them on EM, we are encouraging pro-social activity that is going to make our communities stronger. So we have to constantly be looking at EM and the value of EM as an intervention. We should never just say, oh, this is something extra we can just add that's going to just make us safer. We have to have a critical look at it all the time. That's what I would say is my final point, is let's continue to look at how much of this we need and how we're using it.
All right. Well, thank you so much, both of you, for just giving us so much great information. It's been a lot of fun asking questions from the group and hearing what they've got to say and what you've got to say. I'm going to have some closing remarks real quick from our state chair, Joseph Michael Carr. So I'll go ahead and turn it over to him real quick.
Good evening, everyone. I'm Joseph Michael Carr, and I want to say this was a wonderful evening. I want to thank our guests, Ali, Rebecca, and also Senator Peters. I think that this was a very informative session. And for those that are not familiar with IVI-IPO, we are doing these town hall sessions once a month now. And once again, I want to thank everyone tonight for coming out. Take care.
Thank you.
Thank you all.
Thank you all. Have a great night.
Good night.
Thanks very much.